If you're friendly with the defense attorney who questions you during a deposition, now, will that help the value of your case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. And now, during the course of your lawsuit, guess what? The defense lawyer has an opportunity to ask you questions, and that's a process known as a deposition. We also call that an examination before trial. And it's really sworn testimony, but it takes place in our office. And even though there's no judge present, even though there's no jury present, there is a court reporter there to record all of the questions that you are asked and all of the answers that you give. And the answers that you give carry the same exact weight as if you are testifying at the time of trial. So now you think, because you're a schmoozer, because you love to talk to people, because you love to network with people, you think that if you are friendly or overly friendly with the attorney who's going to be questioning you, that somehow you're going to cozy up to him or her, and that's going to help you and help the value of your case. Will it? In my opinion, the answer is absolutely not. And you might be thinking, why not? It works every other time. It helps in every other facet of your life. And you know what? That's a very good observation. The problem with that thinking is, from the moment you walk into our conference room and the defense lawyer is sitting there, you are being judged. You are being judged in how you dress. You're being judged in how you speak. You're being judged in what you remember. You're being judged in your mannerisms. Now, why do they do that? They do that because they're trying to decide in their own mind exactly what type of witness you are going to be at the time of trial, if and when your case comes up for trial. And that's a very important judgment. That's a very important observation that the defense lawyer needs to make. Now, you might be nice, you might be outgoing, you might be overly friendly. Guess what? It's not going to make a bit of difference when the defense turns around to evaluate whether or not you are slightly more likely right than wrong that what you are claiming is true, that your doctor violated the basic standards of medical care. They're not going to say, oh, well, he's really a nice guy, and because of that, yeah, we're going to give it to him, the fact that he's bringing this claim, yeah, we agree with him. No, no, no. They're going to be relying on their medical experts to tell them whether or not the doctor violated the basic standards of medical care. They're not going to care whether or not you are a really nice guy when they evaluate whether the doctor's carelessness was a cause of your injury. Instead, they'll be looking to their expert for that answer. Nor will they be looking to see what type of damages, what type of injuries you suffered as a result of this carelessness. They don't look to see, hey, this is a really nice guy, he's overly friendly, and because of that, we can see that he suffered these injuries and that he suffered some type of damages. Guess what? That is not what's going to help them assess the value of your particular case. What will it do by being overly friendly, by being nice, by being polite? I'll tell you what it'll do. It'll help them understand that you are dangerous. And I say that in the nicest of ways because it's going to mean that there's a risk. Because now when you go in front of a jury and now you put on your charm and now you try and tell the jury in your own beautiful way exactly what happened to you and why these injuries are so disabling to you, guess what? Now the defense is going to recognize, hey, wait a second. The defense and the jury is likely going to like you. You're going to make a great witness, and because of that, they are more likely to believe you at the time of trial than someone who is angry, who is vicious, who is nasty, who is obnoxious. That's where it comes into play. Keep in mind that when you come in for a deposition, the defense attorney is going to be asking you lots and lots of questions about what occurred to you and why. And the fact that you are nice, the fact that you are polite is important, relatively important, but it is not going to affect the value of your case in deciding whether or not there's liability, causation, or damages. Why do I share this with you? I share this with you because it's a beautiful day today and I'm testing out some new video equipment, and I thought this would be useful for you to understand how these types of cases work. I do recognize that you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @ Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.